is number 24-40709, Haverkamp. Mr. Weiss.
Good morning, Your Honors, and may it please the Court. My name is Samuel Weiss. I represent Bobby Lee Haverkamp. I'll try to reserve 5 minutes for rebuttal.
Okay.
To open with, defendants' sovereign immunity arguments, some of which were adopted by the district court, are in conflict with 50-plus years of this court's precedent in prison cases, among others. The Supreme Court has been clear on Rule 12 to get past sovereign immunity just for purposes of establishing subject matter jurisdiction. You need to allege an ongoing federal violation. You need to identify a state official with some connection, and that's it. Defendants' argument that division between ministerial and discretionary duties and asking that this court should, on Rule 12, hold that any sort of discretionary legal standard, a plaintiff can't obtain an injunction. And in fact, it can't even proceed to the merits, which flies in the face of more than 50 years of this court's precedent. We give a few examples, like this court's opinion in DeLauder, which is a 2018 decision that is just square on the facts, that looked at sovereign immunity when a plaintiff was bringing a challenge to obtain a surgery, and this court held that applying Supreme Court cases like Verizon, that the act of alleging a constitutional violation, not considering the merits of the violation, just alleging constitutional violation with the defendant with some connection to it, was sufficient to get past sovereign immunity. It's telling defendants' cases, there's a reason that the authority they rely on here in terms, and I'm talking about the sovereign immunity of the remedy, not the sovereign immunity of individual defendants. There's one case that's Richardson, that's an appeal from an injunction that's not under Rule 12. And there's a qualified immunity case from 40 years ago, and there's another case that's about the substantive standard, the First Amendment. This issue comes up all the time. It's always resolved in the same way. And I think a telling example, defendants rely on Gibson versus Collier. They think, in fact, they're unable to distinguish cases like DeLauder. They say that this court should disregard DeLauder because it came before Gibson. But look at Gibson itself. Gibson, virtually the same official capacity defendants, represented by the same counsel, held that there was subject matter jurisdiction. The district court entertained a challenge to the authority under Ex parte Young and applied the law, which is that merely alleging a constitutional violation with the defendant with some connection to it was enough. Then it went on to reach the merits. Obviously, it would have been inappropriate for the court to reach the merits in Gibson had the court lacked subject matter jurisdiction. When this court held it on appeal, similarly, defense counsel, the same defense counsel here, said that this court did have subject matter jurisdiction over this case, and that this court should reach the merits, and the court did reach the merits. Now, they held that the plaintiff there seeking the remedy of sexual assignment surgery did not have an Eighth Amendment claim, but that's not the inquiry before this court here. It's whether this court had subject matter jurisdiction, whether the district court had subject matter jurisdiction, because the allegations of an ongoing federal violation with a defendant with some connection to it is sufficient for Ex parte Young. If there are no questions, I can address the specific defendants.
Okay, yeah, why don't you pivot to your other arguments?
Okay, so the legal standard, which defendants don't mention very much in their briefing, is not a demanding one. These aren't damages claims. These are official capacity injunctive claims where in cases like Democratic Party versus Abbott, this court has held there needs to be a scintilla of evidence connecting the specific defendants to the enforcement of the policy.
What is the relief that Haverkamp seeks?
Haverkamp ultimately seeks sex reassignment surgery.
But is there a difference? As I understand it, there's sort of an affirmative injunction request, give me the surgery, order the surgery, and a negative injunction request, which is what?
Yeah, so that's absolutely right. And the first thing to say here is that we're not on an appeal from a preliminary injunction. We're not on appeal from a trial. We're on appeal from a Rule 12 decision about whether the court has subject matter jurisdiction to move forward. Now, there's two ways to frame the potential injunction. One is an affirmative injunction, which, as we've said, we think is totally valid, which is give me the sex reassignment surgery. Now, that doesn't mean...
And that's valid even though Gibson says a blanket ban on... I mean, they followed the First Circuit in Banc that said blanket ban on this surgery is okay.
Exactly. So what Gibson addressed the Eighth Amendment argument. It didn't address the 14th Equal Protection argument.
Yeah, but is there a difference, really? I mean, if anything, the Eighth Amendment argument it hinges on deliberate indifference.
Right.
They said it's not deliberate indifference to deny a surgery that is, at best, hotly disputed as to whether it's necessary medical care or not. And Gibson appears to bless a blanket ban. Therefore, how could there be any claim here?
Well, I think there's two different legal standards. And I think to the extent that you're suggesting that Ms. Haverkamp will have a hard time proving up her equal protection claim, I think that that is both very possible and also not before this court, because the merits of her equal protection claim are expressly not before the court. Now,
well, but there has to be a federal claim asserted, an ongoing violation of federal law. I don't think you can just make one up and say, look, we're good, it's the merits, you can't go farther. I mean, that prong of ex parte Young means something.
You're right, it does mean something, but...
What does it mean?
It means that, well, it's a good question, because the Supreme Court has...
That's why I asked it.
Yeah, the Supreme Court has said you need to allege an ongoing constitutional violation. Again, even Gibson itself held that it was enough to get that this identical remedy was enough to get past Rule 12, that was enough to get past Ex parte Young, and then
in the deliberate indifference context.
Yes, I think the equal protection claim, without getting too much into it because it's not before us, but the equal protection claim is that transgender and cisgender women are treated differently with respect to this particular surgery. Now, I think defendants, the district court did not rule on the merits. It ruled on a 12b1 motion, and it denied the summary judgment motion as moot. Defendants chose not to contest that or urge affirmance on an alternative ground. Obviously, there was a very significant Supreme Court decision about equal protection and healthcare for transgender people. Defendants...
You talked about Scrimetti?
I am. Defendants did not file a 28J letter. The state of Texas obviously has an army of talented lawyers who can choose which arguments to put before this court, and it didn't put that argument before the court. And I think backdooring, whatever concern this court has about the merits, backdooring it into the sovereign immunity analysis would be incorrect.
Well, put the merits aside, I'm concerned about Ex parte Young and how far it would allow us to go. That's why I asked you about what relief is being sought here.
Right. So I'll get back to your question, Judge Wilson, because I didn't answer it. The affirmative injunction versus the negative injunction. And again, this is just what the district court has subject matter jurisdiction to entertain. We're not up on a preliminary injunction. We're not up after a trial. But there's an affirmative injunction that says refer her for sex reassignment surgery. Let her go see a surgeon and be evaluated for sex reassignment surgery, which she has not been permitted to. And there's also just a negative injunction. So the policy at issue on transgender healthcare doesn't actually it doesn't specifically dictate that sex reassignment surgery is forbidden. That's been the defendants, Linthicum and Murray's interpretation and enforcement of the policy. But there's testimony in the record that Dr. Murray went to everybody at the physicians at the gender dysphoria clinic and said, you are not permitted to refer people for sex reassignment surgery. So there is a negative injunction that just says the policy doesn't state that. Stop interfering with the line doctor's provision of medical health care.
So the affirmative injunction relief that is being sought here would include a simple evaluation for suitability for the surgery.
Correct.
And I mean, currently, no doctor has recommended the surgery.
Correct. It's
so if we send this back, they've at least got to evaluate you for this surgery.
Of course.
And a doctor says, no, not suitable. He has no claim.
That's correct.
Does that undermine standing here?
I don't.
Is there redressability or traceability problem?
I don't think it undermines standing, because what we have here is we have a record in which we have Haverkamp's own treating physician saying, number one, the doctors are forbidden from referring her to surgery. And number two, it is appropriate to refer her to surgery now.
But Dr. Myers said that years ago and is no longer the treating physician.
He said that years ago, and he also said that in testimony of this case.
As an expert, not a treating physician.
That's right. But there's obviously a bit of a catch-22 here for defendants to say, well, there's no standing because no physician has actually referred her, and also all the physicians are barred from referring her. It's the very bar in question that she's challenging. Now, and I'll note that defendants have conflicting testimony saying that there is no bar, and it's just, there's over 500 people in the sex reassignment, in the gender dysphoria clinic, and the physicians have never referred anybody for sex reassignment surgery ever, and there's been all these public statements saying there will be no sex reassignment surgery ever, but actually they would consider it if there was a referral. That's a contested fact, and defendants concede on pages 31, 32 of their brief that the district court didn't resolve that contested jurisdictional fact, and it would be appropriate to remand for resolution, not decided in their favor.
If I apprehended, Dr. Murray is the hinge here, because your contention is that's the correct defendant. He can afford relief. He's charged with enforcement of the policy. But this goes back to the district court's grappling with discretion. If a physician says, I recommend the surgery for patient X, and that's going to be reviewed by Dr. Murray, and Dr. Murray says, I don't. How in the world is there a claim there? Because, again, under Gibson saying there can be a blanket ban on this, and under Gibson's grappling with the hotly contested medical data, research, and opinions, if Dr. Murray is consulted and says, no, not going to refer this patient, there's no claim. There's no injury, is there? Or is there?
No, I think there very well may not be. But I think the only issue I would take with the question is that goes to discretion. I mean, that does go to discretion in the substantive standard of constitutional prison law. But defendants attempt to take the discretion, which is in medical care cases and in every other type of prison law case, and backdoor that into the sovereign immunity analysis and make it a Rule 12 subject matter jurisdiction inquiry is incorrect. I think what you've said is right about the merits of Haverkamp's claim, but the merits of Haverkamp's claim aren't before us.
But it would suggest redressability or traceability here, which is standing, which is not merits.
That's not merits, but what we have is, and this is true with the specific defendants, it's true with the standing issue that you raised, which is that this kind of injunctive litigation isn't meant to trap plaintiffs into this catch-22.
Well, but we can't issue an opinion that basically says, well, in this set of medical cases, the inmate is actually entitled to the medical care that the inmate wants.
No,
because that's completely contrary to the law.
I agree. I think,
and the difference between DeLauder in this case may be that a patient presenting with DeLauder's hip issues, whatever, there'd be pretty much a universal consensus. Another thing Gibson talked about and contrasted, that the surgery was required. That's lacking here.
I don't think that that's wrong. I just think that, and I'm up against my time here. I'll just finish this one question.
You have
But
time to
thank you.
complete your response.
That I think what muddles this question, and it would be a little clearer in other contexts, is that in a straight Eighth Amendment case, it's like Gibson itself, like DeLauder, it's clear that the merits and the sovereign immunity inquiry can't be conflated. So if what you're saying is, well, defendants have a ton of discretion about provision of medical care, which is true as far as substantive prison law. It's also true about religious freedom in a prison, free speech in prison, search and seizure in prison. If defendants have a lot of discretion, and therefore the court has no subject matter jurisdiction to consider the inquiry at all, no plaintiff could ever get to the merits. And I think what's muddling this case a little bit is that her claim is under the 14th Amendment, and the defendants are making merits arguments about, are sort of discussing the weakness of her case as an Eighth Amendment claim, which, this court has already held in Gibson, and may very well carry the day here in terms of her equal protection claim, whether because of Scarametti or whether because of the issues that you raise. But it's nonetheless as equally true that taking that idea of discretion and importing it into a sovereign immunity Rule 12 analysis is not consistent with more than 50 years of this court's precedent.
On rebuttal, I want you to address the fact that your client would not even qualify, even if the prison agreed to pay for it because of his medical condition. They're not going to back off of the fact that he's of advanced age, he's got obesity, range, mass index, diabetes, high blood pressure, high cholesterol, high risk for chronic kidney disease and failure. He's not going to be subjected to surgery. So you're wasting everybody's time.
I'll address that.
You
Thank
would
you.
explain that. Thank you.
All right, you've reserved your rebuttal time. All right, Mr. Fraser.
Good afternoon, Your Honors, and may it please the Court. I'd like to keep focusing on the injunction issue because I really think it is the simplest way to address this somewhat unusual case. Under Ex parte Young, federal courts cannot compel state officers to exercise their discretion in particular ways. Here, Haverkamp seeks an injunction that would require Texas to perform sex reassignment surgery as a medical treatment for gender dysphoria. But as this court has explained, these types of treatments are novel, complicated, and highly controversial. And the Constitution simply does not give federal courts the authority to make these kinds of controversial decisions on behalf of states. And so the decision whether to allow this medical procedure for this inmate is a highly discretionary medical decision. And therefore, the district court was correct that it cannot compel Texas to do so here. Judge Wilson, I think you brought up some good points. In Gibson, the court was clear. This is a sort of hotly debated issue within the medical community. And I think there's an easy way. My friend on the other side said that we're going against 50 years of case law as well as DeLauder. DeLauder was an Eighth Amendment case. That's the easiest way to distinguish it. Before Gibson, it was not clear whether denying this kind of procedure to an inmate, whether states had discretion to do so, because of course the state would not argue that it has discretion to deny medically necessary treatment under the Eighth Amendment. DeLauder was a hip replacement case. The state is not arguing that under the Eighth Amendment, it has the authority or the discretion to deny those kinds of medically necessary treatment.
But what are the differences between the Eighth Amendment and the equal protection, the 14th Amendment claim? There are differences, right? I mean, DeLauder's a deliberate indifference case. This is not. This is an equal protection case.
Correct. There's a difference in the constitutional theory, but there's not a difference in the requested remedy. So Haverkamp, as my friend on the other side conceded, is seeking an injunction that would require the state to perform sex reassignment surgery.
But the state does perform these or similar surgeries for biological women. And they're at least alleging that the classes are equivalent. In other words, there's an equal protection claim there because Haverkamp is treated differently?
So again, I think if you focus on what Haverkamp is asking a federal court to require the state to do. So let's say there's a hypothetical situation in which there is actually an equal protection violation here, which of course I don't think that there is, particularly after Scrimeti and based on the sort of unusual claims that are being made. If the state were exercising its discretion to allow some sort of cosmetic procedure for one sex but not the other, a federal court could perhaps enjoin the state to treat the sexes equally under the law. It could not require the state to exercise its discretion to allow the procedure for the disfavored group or stop providing it for the favored group. It would simply be up to the state how to remedy the equal protection violation. And I really think a declaratory judgment would make sense as well, because the court could just say, you state are violating the Equal Protection Clause. And as the Supreme Court has held many times, the state is presumed to follow that court order. And that's why declaratory judgments are not advisory opinions. The problem with that sort of hypothetical remedy that might be permissible here is that it's squarely forfeited. Haverkamp did not in the complaint or in the opposition to the state's 12B1 motion articulate any kind of injunction that would leave it up to the state in its discretion to determine how to remedy the equal protection violation. If you look in the record, this is at pages 2580 to 81, this is in opposition to the state's 12B1 motion with respect to our argument about the injunction. Haverkamp said, quote, Haverkamp seeks A, an injunction ordering defendants to provide sex reassignment surgery as a treatment for gender dysphoria, or B, a prospective injunction prohibiting defendants from implementing policy G5111 in a manner that prohibits it. But of course, that's really just two ways of saying the same thing. In other words, you can't request an affirmative injunction and then just use a double negative and say that you're requesting a negative injunction. Effectively, Haverkamp is saying, either give me the surgery or stop not giving me the surgery. But the only way for the court, for the state to enforce that injunction would be to give Haverkamp the surgery. And because that is such a complicated, controversial, discretionary medical decision, the court simply can't order the state to provide it here.
But what about an order that says you can't enforce a blanket prohibition and you've got to assess patients case by case and let the treating physicians recommend or not recommend, et cetera?
I don't think Haverkamp would seek that kind of injunction because it would be squarely foreclosed by Gibson. Gibson said that the state can categorically ban this procedure, either categorically or on a case-by-case basis. And
Well,
in fact,
I heard counsel to say that's exactly one of the options or one of the remedies that Haverkamp is seeking, just to be evaluated.
well, if you recall, Your Honor, in Gibson, the plaintiff asked the court to remand for a sort of individualized determination as to whether sex reassignment surgery was necessary for him. And Gibson said, we don't need to do that because it wouldn't make a difference. You can ban it categorically, and I think Judge Ho said a single dissenting medical opinion does not change the legal answer.
Right, Gibson grapples with the universal consensus and how it doesn't mean unanimous consensus, et cetera. And you heard my exchange with counsel opposite. I mean, how far does Gibson go toward foreclosing these claims here? I do think there's a difference in a deliberate indifference Eighth Amendment case and the one that's alleged here now, today.
I think it's relevant to both claims because if Gibson stands for anything, it stands for the proposition that whether to provide this surgery is a discretionary medical decision that is up to the state. So to the extent the plaintiff is asking for an injunction that would require the state to perform the surgery, that requested injunction is barred by Ex parte Young. And again, I think the briefs do get a little bit closer towards articulating what could be a permissible remedy under Ex parte Young, which would be some kind of injunction saying, you state have to treat the sexes similarly under the law with respect to this policy. But again, it's simply forfeited. It was never raised before the district court. It's not in the complaint. It was raised for the first time on appeal to the extent that it was raised at all.
But do we get to that when we're grappling with jurisdiction and immunity? I mean, in other words, how far can we peek into the merits?
I really don't think it's a merits inquiry at all, Your Honor, because all we're saying is what is the remedy that the plaintiff is seeking, and is the remedy barred by Ex parte Young? To the extent that there's a permissible remedy that could hypothetically exist, it's been squarely forfeited. If you look at the remedies that are actually requested, which again are articulated in the complaint and in Haverkamp's opposition to the 12B1 motion, all Haverkamp has asked for is either provide the surgery or stop denying the surgery. Those are just, it's a sort of semantic trick. They're two ways of asking for the same thing. And I also don't think Haverkamp would even want necessarily an injunction saying you have to treat the sexes equally, because there's not even an allegation that, for example, the state is allowing these procedures for one sex but not the other. And at the end of the day, Haverkamp wants the surgery. And so there's no way around the fact that Haverkamp is seeking an injunction that requires the state to perform it. And to get to your point, Judge Clement, I think you're absolutely right. The jurisdictional fact-finding that the district court did here in terms of this is an 80-year-old inmate who has many sort of exacerbating medical problems, that makes the decision whether to provide this particular procedure for this particular inmate even more discretionary, just as it would be even more discretionary to perform a sort of invasive medical procedure on any elderly inmate.
Well, but we're getting really close right here to substituting our judgment for a treating physician's judgment. How is that proper?
I don't think so, Your Honor. Again, as Gibson said, a single treating physician's opinion would not change the sort of background fact, as the Supreme Court emphasized again and again in Scarametti, that this is just different in kind from other kinds of medical procedures. It is extremely novel, it is extremely complicated, it is extremely controversial. And states are afforded particular discretion when there is medical and scientific uncertainty, which is the case here.
But what they don't say in Scarametti, I mean, they're dealing with minors, right? They don't say, well, there's no claim here that can be articulated for this.
Your Honor, 2 points.
Does Clement just foreclose any plaintiff in Haverkamp's position from asserting a claim?
I think that it absolutely forecloses the equal protection claim, and I'm only saying that to answer Your Honor's question. I agree that we don't need to get into the merits. I also don't think that Scarametti itself is limited only to minors. For example, Haverkamp cites the Fowler case from the 10th Circuit extensively. That's the case where the 10th Circuit found an equal protection clause violation where the state was not allowing transgender folks to change their sex designations on their birth certificates. Well, the state filed a cert petition in that case, the Supreme Court held it, and after Scarametti, the Supreme Court granted the cert petition, vacated the opinion, and remanded for a new analysis in light of Scarametti. So I don't think that Scarametti is limited to minors. Let me see. So DeLauder, again, DeLauder's an Eighth Amendment case. This is different in kind. It was before Gibson held that states may categorically ban this kind of procedure under the Eighth Amendment. Certainly, the state would not argue that it could categorically ban hip replacements under the Eighth Amendment. And just as to standing, Your Honors, I think the reason why this case is a little bit unusual is because it's not entirely clear what the policy is that Haverkamp is alleging is unconstitutional. To the extent Haverkamp is alleging that no physician may refer any patient for sex reassignment surgery, I think perhaps the correct defendant, to your Honor's point, Judge Wilson, would be that the correct defendant might be the current treating physician. If the theory is that the policy is that experts can refer an inmate for the procedure, but it's then denied, then I think Dr. Murray could potentially be the correct defendant. But again, Judge Wilson, you're correct that Haverkamp would not have standing in that case because, as this court said in Haverkamp 1, there's no indication that Judge Meyer continued to recommend sex reassignment surgery at the end of the 12-month hormone treatment. There's no evidence in the record or allegation that Dr. Meyer ever actually referred Haverkamp for the procedure and then it was denied. And to the extent that the allegation is something else, that the policy is sort of allowing sex reassignment surgery for women but not for men, or allowing different kinds of medical procedures for biological women that are not treatments for gender dysphoria, but are completely different and to restore anatomical function, there simply is no policy within the prison to that effect. So it is difficult to identify the correct defendant who has a special duty to enforce a policy that the prison doesn't have.
Well, let me ask you this. Is this the first case, this plaintiff, asserting this claim for this type of surgery such that there is no policy because this is the first one? Or I understand the conversation about female, but I mean, is his sort of the first one, so there's no policy because there hadn't been a prior claim, or is he alleging that there is a policy that covers his situation, which is valid? I'm not quite sure I understand.
I appreciate that, Judge Stewart. And so there is a policy G5111, and the reason that the case is sort of unusual because Haverkamp is seeking an affirmative injunction is because the policy does not require or prohibit anyone from doing anything. It is a discretionary policy by definition, so it says that gender dysphoria will be treated on a case-by-case basis as clinically indicated, and it's sort of a discretionary decision left up to the experts within the prison. So if Haverkamp is seeking an injunction that is requiring the state to interpret a discretionary policy in a particular way, then by definition, Haverkamp is seeking an injunction that would intrude on the medical discretionary decisions of state officers, which is exactly what Ex parte Young and Richardson prohibit.
But what Haverkamp is alleging is there's really not discretion because the state has said, we're not allowing it. We're not even accepting a treating physician's recommendation. There's no stated blanket prohibition, but there's really a conspiracy of silence, so to speak. We're not allowing it. And you've got Linthicum's, Dr. Linthicum's statements that were made out to the public saying it's not allowed under the plan, this surgery. So it's not a question of does the policy outright prohibit this or outright prohibit that. It's silence. But I think what they're alleging is the silence is strategic.
It's possible that that's what they're alleging, Your Honor, but again, this goes back to Gibson. The state may categorically ban the procedure. And I don't
But the state hasn't, and because of ambiguity on the state side, maybe that makes it a little bit difficult to determine what the relief is that's being sought. Does that make sense?
I don't think it does. I appreciate the complexity, but I think at the end of the day, if it is true under Gibson that the decision whether to allow the procedure is discretionary, and the plaintiff is seeking an injunction that requires the state to provide the procedure, then by definition, the plaintiff is seeking an injunction that is barred by Ex parte Young. Because if Gibson means anything, it means that it's up to the discretion of the state whether to provide the procedure. That is why the state may categorically ban it without violating the Eighth Amendment. If the state didn't have the discretion whether to ban the procedure, then of course there would be an Eighth Amendment violation.
Now, you mentioned the proper defendants. The state's been a little cagey on the proper defendants because this is the second go-round up here for this case. And at one point, the state represented that Dr. Murray was the right defendant. And now the state is saying, well, Dr. Murray's not the right defendant because he doesn't enforce or whatever it is. Can you clarify where we are on that? I mean, I'm assuming you're traveling under this sort of rationale in footnote 8 of the first decision. Can't be stopped because it's jurisdictional, but it's sort of a fig leaf, isn't it?
Well, a few responses, Your Honor. First, it can't be stopped because it's jurisdictional. That's what the court suggested in that footnote. More importantly, I think what the court said is these are not inconsistent statements, which of course is a requirement for judicial estoppel. If you look at the email, which is the only new thing from Haverkamp 1, what counsel for Haverkamp said is he emailed trial counsel for the state and said, we would like to substitute Dr. Penn as a defendant. Do you object to that? And what we said is you don't need to substitute Dr. Penn as a defendant because Dr. Murray has the authority essentially to ensure that the terms of the injunction would be followed. And as the court said in the same footnote, that is not the same thing as saying Dr. Murray is a proper defendant under Ex parte Young, which is a legal conclusion. Those are just not different statements. And
well, is Dr. Murray the right defendant?
Dr. Murray is the right defendant in the sense articulated in the email and in the sense articulated to the magistrate judge before Haverkamp 1. He does have the authority to ensure that the state or TDCJ, UTMB complies with the terms of the injunction. I don't know that that's exactly the same thing as saying Dr. Murray has a special duty to enforce the challenged policy, not only because it's difficult to articulate precisely what the policy is that they're challenging, but again, I think if the allegation is that the policy is that a physician may recommend the surgery, but it is then denied, then it's possible that Dr. Murray is the correct defendant. I think it's a legal question that ultimately the court would have to determine. But the problem there is that Haverkamp would have no standing in that situation because there's no evidence. It's essentially undisputed that Dr. Meyer never actually made a referral within TDCJ UTMB for the surgery that Dr. Murray denied. Dr. Murray testified that he never read Haverkamp's medical records, never received a referral for sex reassignment surgery, and essentially had no decision-making at all with respect to Haverkamp's treatment.
But didn't Dr. Myers say, or hasn't he said, I was told it wouldn't be approved and therefore I didn't try? I mean, it's pretty clear he thought that the surgery was merited here at some time ago.
Dr. Meyer testified that when he was hired, he was told by people in the prison like Dr. Penn and Dr. Murray that the surgery is not essentially allowed as treatment for gender dysphoria. I think that that's correct, at least right now. Again, this is a novel sort of sui generis medical treatment where things are changing rapidly, as Skermetti said, as Gibson said.
Yes,
And
but
so
somebody would be the proper defendant. And I guess we're talking about Dr. Murray and Dr. Linthicum, correct? At this point. So it sounds to me like Dr. Murray would be a proper defendant.
I think that could be true, Your Honor. I do think that could be true if the allegation is that, again, physicians can recommend the surgery, but then it was denied by Dr. Murray. I don't think that Haverkamp would have standing in that case because it's essentially undisputed that that hasn't happened here. And if the allegation is that it can't be referred, then I think the person who would be enforcing the allegedly unconstitutional policy against the patient would be the treating physician. So that would be whoever is currently treating Haverkamp for gender.
Is it the state's position that you'd effectively need both as defendants?
I don't think so, because I think, again, it would depend on how the allegedly unconstitutional policy is articulated. It's not very clear exactly what the policy is that Haverkamp is alleging. But again, just backing up, I think the simplest way for the court to address this case is to just say, what is the injunction that Haverkamp is requesting? It is an injunction, whether formed in the affirmative or the negative, that would require Texas to perform sex reassignment surgery as a treatment for gender dysphoria. But as the Supreme Court and this court have emphasized repeatedly, this is a novel, complicated medical decision that is left up to the discretion of the state, and so federal courts can't compel the state to do so. And so I think the district court was correct on that point, and for that reason, I think the court should affirm.
What about Dr. Linthicum?
I think it's clear from Haverkamp 1 that Dr. Linthicum's sort of supervisory role over more than 100,000 prisoners is not sufficient such that she is a proper defendant. I don't think anything has changed since that decision. I do think Dr. Murray is a much more difficult question, and I think that's at least in part why the district court didn't answer that question and decided to instead resolve it on the injunction issue, because I think that's a much more straightforward and easier way to address this somewhat unusual case.
All right,
Thank you, Your Honor.
sir. You have your argument. All right, back to you, Mr. Weiss. Are you saying that even assuming the decision is discretionary, the discretion must be exercised in favor of your client because to do otherwise violates the 14th Amendment?
I'm saying that's what in a merits holding, if Haverkamp years down the road was able to win on the merits, would hold. For now, on Rule 12, the mere allegation of a violation is sufficient.
Well, I understand it, but I'm trying to further understand what the mere allegation is.
The mere allegation is...
Go ahead.
Oh, pardon, I'm sorry. The mere allegation is a violation of the 14th Amendment for differential treatment on the basis of sex.
Well, I mean, it's one thing to just say that. I mean, that sounds like out of a horn book. But, I mean, in this context, trying to, you don't dispute that it's a novel or not the typical, everyday medical procedure, et cetera, right? So it's not something maybe even like the hip surgery, which may be more routine, quote unquote, but it's not. So, I mean, acknowledge that. So are you asserting that there is a policy that fits like a glove? This circumstance and the policy itself per se is violative of your client's constitutional rights, or that there isn't a policy, it's just the practice?
Ms. Haverkamp alleged that there is a de facto policy, and after jurisdictional discovery, put forth testimony that the doctors were told that they were forbidden from referring people for treatment. But in so much as your question, which is mostly addressed to the merits aren't before this court.
Well, I'm clear that the merits something, but, we don't come in here with a blindfold on. We know what you allege. You allege somebody who's 78 years old wants a, vaginoplasty, who's 28 or whatever when he went to prison. So, I can't blind myself to the facts. I'm not trying to get to the merits of judging, quote, whether that's redressable, but even in a 12B1 or 12B6, you've got to look at what is, up front, taking the facts in the light most favorable to you. Does this state a claim? And here we have Ex parte Young, which has particular strictures, so we're just not trying to judge the merits or divorce ourselves, but see it the way it was played before in terms of, is there a policy that's straitjacketing what you're asking, or is it saying, well, it's not really a real policy, but everybody's saying thou shalt not do it, which is tantamount to a policy. I don't know.
It's the latter, but the question of whether she stated a claim also wasn't before the court because defendants didn't file a 12B6 motion. They only filed a 12B1 motion.
I got you. It's a 12B1 that's in sovereign immunity. They want to stop you at the door.
Right.
And never get there.
And if I may say a couple things to my friend on the other side's argument, something I said that defendants have no response to. Why did Gibson have subject matter jurisdiction? That's the exact same remedy. The court held there was subject matter jurisdiction, that Ex parte Young was waived. Defendants didn't even contest it, and it's the same counsel. It's the exact same remedy. Why was there subject matter jurisdiction in Gibson? Because merely alleging a constitutional violation is enough. Defendants are arguing, well, it's different because it's the 14th Amendment, it's not the 8th Amendment. There's no principled basis for that whatsoever. The idea of it's discretionary to provide medical care, it's also discretionary, housing, accommodating religion, accommodating speech. This would move the merits of every prison case to 12B1, would allow defendants to take an interlocutory appeal on all of them.
But I'm not sure it does. No physician has recommended the plaintiff for the surgery.
Well, yes, because they've been forbidden from doing so.
Madam Clerk, give counsel an additional minute because he's got to answer Judge Clement's question whether the light is red or turns purple.
Certainly. Thank you, Your Honor. To address Judge Clement's question, you said the prison decided that she had too many complications. The prison did not decide that. The prison has never evaluated him. The only evidence in the record of anybody evaluating him is Dr. Meyer, who was her treating physician, and said that sexual reassignment surgery is medically necessary for her, even with the comorbidities. And again, there's no conflicting evidence from that. To Judge Wilson's point, the evidence about comorbidities, that's just the district court and the lawyer. It's not the physicians. The only physician to opine on this said it's medically necessary.
But not as a treating physician.
He was forbidden from referring as a treating physician. But of course, in the whole crux of it is if he had only testified to that in 2016, 2017, defendants could say, well, to waive Ex parte Young, you need an ongoing federal constitutional violation. Instead, what we have record evidence that there is a medical necessity now, and that the physicians are forbidden from referring her to surgery.
All right, in the finale, tell us in a straightforward, declarative statement, what is the holding you're seeking from this panel? Just don't give me an argument.
Sure.
Just give me a narrative of what it is you want to read.
Yes. The district court's holdings as to sovereign immunity both as to the specific defendant in Linthicum and as to the specific remedy, are in conflict with 60 years of this court's precedent. That order is vacated and the case is remanded for consideration of the merits. Defendants may file a 12b6 motion if they'd like.
All right, any
Thank you.
additional questions? All right, it's always good to know what people are looking for, whether they get it or not, but it's just good to know. All right, thank you, counsel, both